Thanks very much, Carla. And first of all, I just want to welcome members of the Two Mother and Baby Alliance that are here in the public gallery with us today, and they've been active not just on this aspect of the scheme, but on everything in relation to the mother and baby institutions over the years. I'm speaking in support of Amendment 2, but also I want to speak in support of my own amendment, which is 62, which is very similar. And I would agree with Deputy Kearns. It was Deputy Sean Sherlock that I suppose first gave us the idea of we could look for a report to be published, and in that way our amendments weren't going to be ruled out of order, because there's really, really important aspects of this scheme that need to be discussed, and aspects that I just don't think anybody really genuinely, if they were looking into their heart, could support these. I just don't understand how it can be that somebody who was born into an institution and spent less than 6 months can be seen as being excluded. So you literally could have somebody 7 months and right next to them somebody 5 months, 3 weeks and 3 days, and they're just totally excluded. We can't quantify the horrors and the abuse and the just appalling treatment that were inflicted on women and children, I know, under the eyes of the state and the religious institutions. Let's not forget them, but the state mainly oversaw all of these institutions. We can't say that somebody suffering who went in for 1 month is less than somebody who maybe spent a year or longer or 6 months. It really is very cynical. It leaves out, as Deputy Karen said, 40% of survivors, and we all know it's a cost-saving measure by government. It can be dressed up in any other way, but the reality is that's why they're doing the scheme this way. It also excludes those who are boarded out, and the argument that's given for that is that it's difficult to identify people. Well, there are so many advocacy groups and so many people working with survivors of mother and baby institutions. It would be very easy, I believe, to identify, and at least an attempt should be made to identify all of those who've been boarded out and to ensure that they're included in the scheme. Again, the costs would be astronomical for the state, but I think that it's something, if we're genuinely, sorry about, we need to stop just talking about it, and we actually need to match our words with action. And the best apology, when I used to work for the trade union, we'd often come across people and they'd say, it's not about the money, it's about we want an apology and we want what was done to us recognised. And I would always say back, the best way of getting that is by actually somebody showing action, and a financial payment, a redress, is one of the best ways that the state can do that, and they can show they're sincere by not excluding anybody, by getting rid of the 6-month rule, by not excluding those who are boarded out, by not excluding also some institutions. So it's only the institutions that were covered by the Mother and Baby Home report, which we all know in itself was flawed. There's huge issues with. There was an amendment or addendum added into that report. So the state, to a certain extent, is acknowledging the flaws and the issues with that report. Yet, all of the institutions that are not covered by that are also left out. So unfortunately, we will not be able to support this bill this evening, because I just can't justify literally what I think pitting survivors against each other, those that have more than 6 months that were born in the institutions and those that have less, and it's impossible for us to support it. I also want to mention the Oak report, because as I have said before in this chamber, that report, for the most part, people were happy with the consultation process and felt that they were listened to, and the report was commissioned by the department. And now we have a situation where the very good recommendations in it are being totally ignored. So again, I just feel like that is nearly double cruelty. It's adding insult to injury to ignore all of those reports. When people were actually finally listened to properly, then all of that is ignored. So it's sort of like that same patriarchal mindset that forced women into the institutions in the first place, and that stood over basically robbing people's children. It's that same mindset that we're seeing throughout this. And I also want to mention the mixed race children were placed as babies not only in the mother and baby institutions, but in nurseries of other institutions. And I feel that this isn't being looked at in terms of the breach of international human rights. And I think that this, along with all of the other points, is just, we have a chance here to actually make a really good scheme to not exclude people. I've often said before that it's difficult to know how you put a price on any of this, but the very first thing you do is ensure that you're not excluding somebody. And a scheme that actually excludes 40% of the relevant people is wrong and flawed to begin with. I think we need to change that. We need to include the boarded out children. We need to also include all of the institutions and look at the actual report that the department commissioned, and let's look at those recommendations. I know there's a lot of amendments, so I'll speak on some of the other points later. But I just feel really, really strongly on that 6 months. I don't think any person that you were to ask could honestly say that they believe that that's fair and that that's right. It's clearly a cost-saving measure, and it really, really needs to be removed. Thank you, Ciancóla. First of all, I know I mentioned the Tune group earlier, but also we have James Sugar and I think Peter Mulryan, who are two of the boarded out children here with us, and they just wanted the point made as well that they were actually given a commitment from the now Taoiseach, Leo Varadkar, about their own cases and that they shouldn't be forgotten. And I think that this is kind of the difficulty that we've had, you know, with government. They're saying one thing and maybe meeting survivors, and yet then when it actually comes to the brass tacks of the situation, we're seeing a totally different kind of approach. And to be honest, I'm kind of struggling for words here, because we've had so many debates in relation to the mother and baby institutions, and we've had so many committee meetings, and we've had them through COVID when we had to really try to figure out how we could bring people up so that we could hear directly from them. And we overcame all that, and as a committee worked really well and really hard together, totally cross-party, might I say. And that doesn't happen very often. And here we are, and it's still exclusionary of so many people. I agree with the other speakers. We need to know why people who have been spent less than 6 months, who were born into institutions, are being left out. And I think the reason, with all due respect, Minister, you don't want to answer that is because the reality is, the answer is, it's a cost-saving measure. And I really believe, if you were in one of the seats over here, I don't believe fundamentally you would agree with this. I don't believe personally that you would agree with this. I also want to briefly mention the religious institutions and the pharmaceutical institutions as well, because they have to be pursued. And I said that at second stage, that we should be looking at how we can pursue them through the courts, because they need to pay their fair share as well. And again, everybody from all institutions, and I know I'm kind of running out of time, but if you just indulge me for 30 seconds, Cathaoirleach, we had a situation here before Christmas in relation to a bill, one of the health bills, where it was going to be guillotined, and then I think for the first time ever in the 7 years I've been in this House, the right decision was made, and they stopped that, and they decided they would come back to it after Christmas. The same thing can be done in relation to this bill now. We can adjourn the debate and go back not even fully to the drawing board, but go back to a scheme that's going to include everybody, and to ensure that everybody who spent even a day or a few minutes in an institution is included in this scheme. And finally, I just want to say, I think Deputy Boyd Barrett has summed up the whole situation and the whole debate in his contribution, and commend him for it.
Thanks very much, Chair, and I'll seek to respond directly to the amendments first. Speak to the amendments first in this section, and then speak to some of the wider points. So the bill as it currently stands provides for a review of the operation of the scheme at section 42. And the intention is that 2 reviews will be conducted on the scheme. The first is an interim one, which will be commenced 2 years after the 2nd anniversary of the establishment day, and one after the completion of the scheme. Section 12 of the bill also provides that the Chief Deciding Officer shall prepare an annual report on the performance of their function, and that each annual report will be laid before the Houses of the Oireachtas. Section 42 sets out a list of matters that should be considered as part of these reviews, and it allows for the Minister to specify any additional matter. I consider that these matters are appropriate to the purpose of this section, which is to allow for a comprehensive review of the scheme as enacted. It's for this reason that I'm not in a position to accept Amendment 2 or Amendment 62, as both amendments propose matters which represent a review of the parameters of the scheme and a broadening of the eligibility beyond what has been agreed by government and what is being provided for within this bill. This is not a function of the legislation, and that would require a distinct government approval. However, I have given consideration to the matters raised at committee stage in relation to the manner in which this review is published and the timescales for commencement. As outlined at committee stage, I did not think it was proportionate or feasible to commence a review of the scheme 6 months after its establishment, as proposed in Amendment 2. However, I was of the view that proposals brought forward at committee stage, and again today by way of Amendments 59 and 60 by Deputies Ward and Funchion, are reasonable. These amendments propose that reviews should be commenced not later than 6 months after the second anniversary of the scheme and the cessation date. Therefore, I am proposing Amendment 58, which provides that the first or interim review of the operation of the scheme should be commenced as soon as possible, but no later than 6 months after the second anniversary of the establishment day for the scheme, and that the review on completion of the scheme should be commenced as soon as possible, but not later than 6 months after the cessation date for the scheme. I'm also proposing Amendment 61, which explicitly states that where a review is completed, a report will be prepared and submitted to the Minister, and that the Minister shall cause this report to be laid before both houses of the Oireachtas. It was always the intention that this would be the case. However, I think in committee stage, Deputy Sherlock pointed out that this wasn't explicit, and I think the amendment now makes the matter explicit. Deputies, as I've acknowledged in previous proceedings in relation to this bill, I'm acutely aware that no one scheme can provide a response to the full range of individual experiences and pain suffered by survivors as a result of the legacy of these institutions. The state is proposing a scheme where applicants will not be required to demonstrate or bring forward evidence in relation to their experience or enter into an adversarial individual assessment process. And this learns from the experience of previous redress schemes. The general payment approach recognises time spent in the institutions, but also the harsh conditions, the emotional abuse, and all other forms of mistreatment, stigma, and trauma experienced in the institutions. And the payments increase based on time spent also recognises the impact of the longer stays in these harsh institutional settings. I've said before, the payment scheme is one element of the range of responses by the state to survivors and former residents. This range of responses includes counselling services for all survivors and former residents, the very significant Information and Tracing Act that was launched in 2021, a service which provides guaranteed access to birth certificates as well as early life information, the establishment of a national centre for research and remembrance, the support for local memorial initiatives, the appointment of a special advocate, a children's fund to provide support for children who are currently experiencing disadvantage, and the significant work to advance the excavation, the exhumation and the identification of the remains of infants in the tomb, in the tomb burial site. I know from my engagement with survivors that redress comes in many forms and means different things for different people. For many people who went through these institutions, key desire for them was the access to their information, and as we know, that is now provided within the institutional, the birth information and tracing legislation. Over 6,500 people have sought information through that scheme, and already just short of 1,500 people have received access to their information, some of them for the very first time. The government has agreed a payment scheme, and as I said before, it has an estimated value of €800 million. It will cover an estimated 34,000 former residents and survivors, recognising the huge impact, the huge scale of impacts that these institutions had across the state over many decades. This is far beyond what was recommended in the Commission's report. It's far beyond even what the interdepartmental group proposed to government. And this scheme stands alongside the other elements of the action plan: information and tracing legislation, the legislation to allow for the exhumation of tomb, the provision of a records and memorial centre. It stands as part of an overall response that the state is making in seeking to, and I've always said we will never be able to do enough, but in seeking to make amends to survivors of these institutions. Thank you.
I don't support this group of amendments, and I have a number of questions in relation to it. I know, Minister, you've said that you said at committee, but I don't ever remember, and I'm open to correction, that there was talk of a dissolution day and the scheme being sort of, you know, dissolved. I know it's not a scheme that's going to maybe last forever, but I'm not comfortable with the fact that we're talking about dissolution of an office as flawed as the scheme is, and then that the transfer of powers over to whoever the minister of the day is, particularly in relation to any outstanding claims or legal proceedings. Like, we often look for reviews in legislation, and if I'm remembering correctly from committee stage, it was one thing that we did agree on, that there would be a review. Would it not be more appropriate at that point to look at how the institution or the agency will be dissolved, or how it will be handled? I'm very uncomfortable with the fact that we're talking about dissolving an office or an agency. I can't think of the correct word, but before this is even up and running. I don't know, I'm very uncomfortable with it, and I think it gives too much power over to the minister and then the department, really, by default, in relation to kind of deadlines. And I find it difficult in a way sometimes to talk about the kind of technicalities of this scheme, because I feel so fundamentally against it because of everything we just discussed in the last amendment. But I definitely don't support this. I don't think that this should be in, and if there needs to be, for whatever technical or legal reasons that someone can point out to me in relation to, you know, dissolving, then can that not be done at a time of review when we review the legislation? Are we not saying that we're going to review it at a 2-year stage? So I won't be supporting these amendments for that reason. Thanks, Chair.
Thanks very much, Deputy. So, Deputy Funchion, in answer to your question, so the establishment of the scheme and the duration of the scheme are set up in sections 5 and 6 of the legislation. So the duration of the scheme is set out there in section 6, and it says, subject to subsection 2, the scheme shall cease to operate on the following day in this act referred to as the secession date, when that's either the date that is the 5th anniversary of the establishment day, or such date that the minister may by order specify that is earlier than that date. So there is a provision for a secession date for the scheme to actually close, and after such point that the scheme is closed, then you would have a dissolution of the office that was designed to provide and base the scheme. In terms of Deputy Sherlock, so again, there are a number of sections in the legislation dealing with the establishment of the chief deciding officer. So the method of appointment is set out in section 8. I think importantly, so the chief deciding officer will be a member of the civil service, but I think it is important to say that their independence in terms of the functions they take place is set out clearly in legislation. So if you look at section 913, it states the chief deciding officer shall be independent in the performance of the functions conferred on him or her under this act. So whereas it is a member of the civil service, there is a clear legislative protection of the independence of the functions under this particular act. There will be an office then established under the chief deciding officer that will undertake the various administrative roles that will be necessary to implement a scheme of this scale.
So we're saying that the scheme is going to wrap up within 5 years, is that correct? Or earlier, potentially, if... Can I just get clarity on that? Yeah, because then why are we doing a review 2 years in? It just doesn't make any sense to me that we would be setting a date now, or setting it in legislation as to when it will wrap up, and we're supposed to be doing a review. I'm sure if we do a review 2 years into something, it'll nearly be at the 5 years by the time it's actually done, the way things operate in this place. So I just don't, as I say, I find it difficult to support any of this going forward, just given the nature of the debate in the last amendment as well. I think we really had an opportunity to do the right thing, and unfortunately that wasn't taken. So anyway, I'm going to be calling a vote on this. So my whole difficulty with this is assigned staff. So where are those staff going to come from? It kind of is a little bit similar to what Deputy Sherlock was talking about earlier. So if you have maybe staff that are existing, and no disrespect to them, but in another role within the civil service, and they're moved over to this, really, if we wanted to be fully 100% independent, the chief deciding officer, you know, he or she should be able to, you know, advertise for staff and decide on what type of staff that is needed for that role. And it should be with that office solely. It shouldn't be assigned staff from the department, because that's sort of the department's way of being in and being out at the same time. And we all know, Deputy Connolly made several references to Caranua, and every time she said it, I was like, I can't believe I forgot to speak about them, because the people's experience with that institution was just horrific. I mean, the stories that you could tell about people's interaction, and this is kind of the fear that something like this it's going to be similar. So I think it's better for everybody. I think it's better for you, Minister, it's better for the department if it is totally independent and you've got no role whatsoever. The department has no role whatsoever in assigning staff. It should be the chief deciding officer, and that's going to end up being a very frustrating role as well if you're asked to do something and then you're like sort of being, your hands are tied. So I really believe that we need to have that as being totally independent. Thanks, Count Corla.
Count Corla. What is being proposed here is not similar to Caranua. The structures, the legal structures are different, and I think that's really important we put that on the record at the start. The decision making, which is the central role, the decisions on each of these applications as they come in, which is the role for the chief deciding officer, is protected in legislation. The independence of that is protected in legislation. Decisions of the chief deciding officer can be appealed to an independent appeals panel, and those decisions can go to the High Court on a point of law. So I believe the protections that you speak about, Deputy Connolly, are built into the decision-making processes. In terms then of the issue of staff appointments, which I think is essential in terms of the actual amendment before us, what you described, Deputy Funchion, in terms of the ability that all staff would be appointed independently, that is almost an entire state agency. That's a state agency model. And, you know, I've spoken about this, and we spoke about it in the Information and Tracing Bill, the amount of time that will take to establish. Now, maybe you think that that should be done, but we've also spoken, and we've all spoken, about the need to act quickly to make sure survivors and former residents can actually avail of their redress. We know the amount of time it takes to create a new agency in this state. Even the work Minister McEntee and Minister Harris are doing in terms of domestic violence agency, they're looking at an 18-month period. So I believe a process whereby we have an independent office in a department, where it can use the strengths of the department in terms of a HR, the ability to get people into relevant places in the right amount of time, but importantly, have a legislative protection of the independence of the decision-making function, is the best way to go.
Yes, you can, yes. Final contribution.
I just want to come back in to say that what the amendment says is that the chief deciding officer should be able to appoint his or her staff independently. The idea of that is the chances of you having to appeal a decision, if you have a genuinely independent staff, it's going to be less. I'm not talking about setting up a whole new state agency, which is different than what we were proposing in the birth and information legislation. I'm talking about if I was appointed, let's say, in the morning as the independent person, and I say I need 5 or 6 or 7 or 8 staff that you go and appoint, there's no way that would take 18 months. I mean, I can't understand how that could be used as an argument. And the thing is, there might be all of the appeals, which I 100%, you know, appeals are really important and they should be independent, and I welcome that part of it. However, you will have less likelihood of appeals if you have a really decent, genuine, independent service that's going by what is right or what's, you know, the regulations and stuff. That's not necessarily somewhat kind of tainted, for want of better words, in their view. And I just honestly can't understand how, what the issue is with this. If the person is supposed to be independent, let them appoint their own staff. So that's one of the key things of being independent. I can't understand it. And part of me is annoyed with myself for being annoyed because this whole legislation is so flawed. It's like Deputy Connolly said earlier, something about, I forget what word she said, but basically they're trying to change something that's already so flawed. But on these minor things, I really do think, Minister, you can concede some of these points. I honestly don't see how there's any difficulty with somebody who is supposed to be independent appointing their own staff. Thank you. Number 11, I actually think we had a discussion on this in committee, and if I'm reading it correctly, the Minister's amendment number 12 deals with the issue. So if that's the case, I'll be happy to withdraw 11, but if we could just get clarity on that first.
Minister,
Thanks.
can you clarify?
So I'm bringing forward Amendment 12 in response to Amendment 11, which also was proposed at committee stage. It sought to specify the Chief Deciding Officer should hold a public information campaign to raise awareness of the scheme abroad as well as in Ireland. While this has always been the intention that the campaign would promote awareness outside of Ireland, the section is being amended so that intention is now explicitly stated. We're just phrasing it in a slightly different way to the amendment proposed by Deputy Funchion, but it will achieve the same goal.
Thank you, Minister. Do we take it that Amendment 11 is withdrawn and Amendment 12 in the name of the Minister is agreed? The Minister having moved it. You were moving it, Minister, aren't you? Thank you. 13 and 14 are out of order. 15 is in the name of the Minister. Already discussed with 4 is number 15 amendment agreed.
Not agreed.
Not agreed. Deputy Funchion.
This is just in relation to the earlier discussion on the dissolution, so we don't support that. So I'm just following on, I suppose, that train of thought. Thanks. Thanks, Count Corla. Yeah, so again, this gives us the opportunity to speak about the time frame, the 6 months. And one of the things that we did in the pre-leg process in the committee was we actually had specialists in childhood trauma come into the committee. And I think it's probably one of the best sessions that we've ever had, because it was so, I suppose, insightful and really interesting in terms of the work and how all of that actually works, and how basically none of us can know or say that if you spent 2 years in an institution, or you spent 2 days, or you spent 2 weeks, you know, so much of it, you can't say basically because you spent more time, therefore, you know, you're more deserving of the redress. So I think that it's, you know, we're obviously looking for Amendment 26 to be supported. I have a feeling, just given the way that this debate is going, that that's not going to happen. But just again to reiterate that it is really, really wrong to exclude 40% of people who are affected by this. You know, you can make all the arguments for, you know, it's difficult to know how you actually genuinely apologise as a state for this. But again, I repeat, you certainly don't start by excluding a whole bunch of people. It's totally, totally wrong. And then in relation to 63, this is to ensure that those other institutions that weren't covered by the mother and baby home report, and there's several institutions, and we all know of many that weren't covered by that report. And I imagine, and I don't know the terms of reference of that report off by heart, so I'm open to correction on this, but I imagine that was supposed to be like a sample, or, you know, a point of reference. I don't believe that it should have been just institutions then that they investigated are eligible for redress. And I just think, like, all of the apologies by the state are really like, they don't mean anything. They're totally meaningless, because when it comes to actually, you know, paying out the money, that will make such a massive difference for so many people, that the trauma that they have is as a result of the actions of the state in conjunction with the religious institutions. You know, there is so many people, for example, who weren't ever able to hold down full-time work. And they're in a different financial situation then, totally based on the fact that they had this childhood trauma. And for us to, well, not for us, because I totally stand against this, but for the government and the department to say that you had to have spent 6 months to qualify, it's just totally, totally wrong. And I don't care if I end up saying that 100 times in here tonight. I just think while we have the opportunity, while we have the time, we have to keep saying it. And again, to the children who are boarded out and treated so horrifically, it's just, we're failing.
About 4 minutes now.
Thank you very much, Count Corla. As I outlined in committee proceedings, I'm not able to accept amendments 27 or 28. This scheme that we're creating is going to be the largest of its kind established by the state. And I think it's important that we're realistic in terms of the timeframes within which the applications under it can be processed. Every intention will be taken to process the applications as speedily as possible, and I want to assure deputies that everything is being done in my department to build the administrative infrastructure to operate the scheme, to ensure that we can have it open as soon as possible after legislation is enacted. But this is complex work. The administration of the scheme will require those operating it to engage with tens of thousands of applicants, tens of thousands of particularly at the start when the scheme first opens. I think in many cases, because of the design of the scheme, because proof of residence in an institution will allow application, for many people, for the vast majority of people, this will be a simple process. But because of the historic nature of the records, there may be occasions where there's challenges. And as we say, there will be in the region of 34,000 applications coming in under this scheme. And it's not possible to anticipate in every situation that there may be some barriers to finding the relevant information necessary to prove an applicant's residency in an institution. We want to move these applications as quickly as possible, but the bill is being crafted to recognise that there may be some more complicated applications, and in that situation, allowing the Chief Deciding Officer to deal with them as soon as practicable is a more realistic timeline, I believe, than some of the deadlines that are proposed by deputies today. The bill does propose to prioritise elderly applicants. If you look at 16.3b, that clearly states, in terms of the Chief Deciding Officer, may accord priority to the examination of an application where he or she considers that it's in the interest of fairness and efficiency to do so, having regard in particular to the personal circumstances, including the age and the state of health of the applicant. So I believe in 16.3b, we have a clear obligation to consider age and health status. So I think in light of that, I'm not in the position to accept 30 or 29. I believe those points are already reflected within the context of that section. Finally, and again as referenced, in considering all of these proposed amendments and the potential concerns behind them that I know deputies are trying to address, well, I'm bringing forward Amendment 57, and this amendment provides within the bill that the Minister will issue guidelines to provide practical guidance to those involved in any aspect of the administration or the delivery of the scheme, and it's anticipated that these guidelines will serve to provide a detailed roadmap on how applications will be handled and the various points where an applicant can expect to hear from the scheme administrators in respect of their application, and those guidelines will also set out in more detail, stemming from 16.3b, how the prioritisation process operated by the Chief Deciding Officer will work.